Aloha, everyone. A pleasure to see you with us today. Thank you for joining us on another one of our Creative Lab programs, a special edition of how to manage your work for hire agreements as part of our legal clinics. Thank you for joining us. And just a reminder that these clinics are for information only. So if you seek any legal advice, please do contact your own legal counsel. I'm Georgia Skinner, Chief Officer for the Creative Industries Division for the state of Hawaii. We founded Creative Lab Hawaii to empower entrepreneurs with the business and creative skills necessary to succeed in today's global markets. Remember that also, if we should have any intermittent signals today, because we are welcoming our featured speaker from Hawaii Island. And in case there are, just please log in again to Facebook, and we're sure it'll be corrected at that time. I'd also like to just do a shout out quickly to our stellar executive director for the Creative Lab media programs, Michael Palmieri. This is the last of our public events that he'll be joining us, and has created such a wave of positive content development, empowerment of local entrepreneurs, and also selflessly, that I have to say that there is just no one better than Michael to be able to lead a vision like Creative Lab Hawaii that would be nothing without him. So Michael, we bid you aloha and excited to see what comes next for you in your career, and to always stay in touch with our creative entrepreneurs here in the state. And now it's my pleasure to introduce our featured speaker today, Julia BROTMAN. As an intellectual property attorney and entertainment lawyer, Julia works closely with creators, musicians, filmmakers, artists, and entrepreneurs to help transform their visions into reality. Julia brings a socially conscious and business-minded perspective to her work. She handles her clients' business and intellectual property interests to ensure that they are protected so they can focus on what they do best, create. And now her work includes IP registration, licensing, protection, and enforcement, as well as contract drafting and negotiation, business formation, and corporate governance and dispute resolution. She's an active member of our creative community and is the lead organizer of the amazing Hawai'i Songwriting Festival on Hawaii Island, and also serves as our co-director for the Creative Lab Music Immersive alongside her father, Grammy and Hoku winner Charles BROTMAN. Her career includes prior work experiences with Warner Chappell Music, CBS Television Network, NBCUniversal, and a host of music placement companies. This all helps to inform the work she does today for our creatives here in the state of Hawaii. Please join me in welcoming the dynamic and wonderful Julia BROTMAN.
Thank you, Georgia. Wow, I guess I gave you the long version of the bio. Sorry.
Well, it's helpful that people know, right? I mean, they want to know who's talking to them today. And again, remember, this is for your information only, not for legal counsel. You'll have to seek your own for that. So please take it away, Julia.
All right. Thank you, Georgia. And yeah, as was mentioned earlier, I'm on the Big Island, and I actually need to close this window because the Waimea wind is just getting a little bit blowing, and it's going to blow my computer away. So sorry about that. All right. So I'm going to share my screen. I have a PowerPoint to show you folks, and then we'll kind of kick it off. So let's see here. I should be sharing, and I'll go into, all right. Can we see it? That's good, unless someone stops me. Okay, so my name is Julia BROTMAN. I am an intellectual property attorney. I work at Meyer Law. It's a boutique law firm based in Honolulu. I'm kind of the Big Island office now, and we have folks on the West Coast as well. It's one of the only firms, I think, that has a very robust intellectual property and entertainment department. I feel very, very lucky to be working here. I started off trying to get into this industry. I didn't know I wanted to be a lawyer. I just knew I wanted to work with creative people, and that sort of led me through a bunch of internships. Someone suggested that I go to law school. I liked it. I interned while I was in law school at CBS and NBC, as Georgia mentioned, and it really helped me understand, what the importance of the legal industry is in the creative industries, and how much we need that here in Hawaii, because there's so many talented creative folks, like all of you who I think are watching. And so I wanted to be able to, come home, work with people like you and help you guys kind of, you know, make your projects come to life. So that's who I am and why I'm here. So we are talking today about work for hire agreements, which come up in a whole bunch of different ways. And so, you know, I don't know exactly who's on the line, but I think we have some folks who are probably on the film side, media production, and then, you know, music industry side as well. We might also have, I don't know, software folks, authors, literary works, and work for hire agreements come up in all of these areas. So I'm going to be kind of directing my comments to the broad range there. So hopefully I get something for everybody in here. So this is kind of my outline. We're going to come back to this so I can walk you through what we're talking about. But I'm going to start off with just a quick little intellectual property overview. Lawyers like to start at the beginning of time when we do anything. And so I think this is helpful just to make sure that everybody kind of knows what we're talking about and where we are in the broader intellectual property world, because there are a lot of different areas of IP. So trademark law and copyrights often get mixed up, but trademarks are kind of a more specific, you know, sister or cousin of copyright law. Trademarks focus on consumer protection, brand identity. So you think about, you know, your mark or your logo that represents something like Nike is a brand, or the Nike swoosh is a trademark as well. So that's trademark. So we're not talking about trademarks today. That's a separate bucket. We are talking about copyrights. Copyright law is the law of authorship. We'll get into this a little bit more, but it's the protection of not ideas, but expressions. So the kind of work that I'm guessing most of you are doing, you know, creating songs, writing music, creating film projects, writing scripts, architecture, choreography. Again, we'll get into that a little bit more, but just to kind of show the distinction between trademark, copyright. Patent is the other kind of big area of IP, and that's the law of invention. So again, you know, in its own separate corner, but there's a lot of overlap, and folks get some of the terminology mixed up. So I thought it's important to go over it at the outset. A couple others that come up, trade secrets are kind of close to trademarks because it again deals with, you know, business issues. Think about like the secret recipes for some of the famous fast food, you know, what's the Coke recipe, what's the KFC fried chicken recipe, things like that are trade secrets. And then right of publicity is another really interesting area that kind of probably intersects with a lot of the work that you guys are doing. We're not getting into it today, but it's something you should know about also. And this is the commercial value of oneself. It's your name, image, likeness, and the right to commercially exploit that. So if your face shows up in a commercial and you didn't authorize that, that's a violation of your right of publicity. Okay, so getting into the copyright basics. Again, this is just kind of setting the groundwork. Some of you might already know this, but I just want to go over a couple more points. So copyright law is based in federal law. It has its roots in the Constitution. Here's the provision. You don't have to, I'm not going to read it out loud, but you should know that, you know, thinking about where this comes from shows us that this was something that was, you know, it's been around since the beginning of the country. Our founding fathers thought that protecting creative works and encouraging creative processes was something important enough to put it in the Constitution. And our laws since have evolved to stay consistent with those ideas. So it protects works of authorship because the idea is that if your works are protected, you're going to be incentivized to do more. And we want a society that is creating as much as possible. So that's kind of where it comes from. You know, copyright, we hear a lot about registrations. Does it need to be registered? No, but it could be, maybe it should be. Again, these are things that I'm not going to jump into a lot here, but just ideas to think about and some terms that I think, you know, probably come up quite a bit for you. I started mentioning this list earlier. These are the kinds of expressions that are covered by copyright law. So there's a pretty wide range, and it's interesting to think about, you know, a choreographic, so hard to say, choreographic work is very different than a computer program or a piece of architectural work, but they're all covered by the same laws. And so that's one of the reasons that copyright law is so complicated, and there's so many different things that us as IP lawyers have to think about when we're helping folks with intellectual property related contracts, because the laws, some of them are maybe a little outdated, we're trying to catch up, but they're created to kind of cover all of these different areas. And so it makes it fun, it makes it interesting, but it also makes it really complicated and challenging sometimes. And again, these are some of the things that copyright law does not protect. So a lot of this is going back to the other areas of IP that I mentioned at the top, trademark things, trade secrets, other types of intellectual property inventions, things like that. You can read through this list on your own time. I should also mention, I think I'll be able to get this deck out to you guys later. So you should have a copy of this. Hopefully we'll be able to get that out. So where does how does something become protected by copyright law? And this is a really important concept to grasp if you haven't already. The language is original and fixed in a tangible medium of expression. So originality was there creativity, is it an original work? Did somebody just, write out the alphabet or did they really put together words in an interesting way for a specific purpose that is not something that, it's something that it's creative. It's a creative work, right? Not copied from someone else, not borrowed from someone else. It's showing your own individual creativity. So that's the originality requirement. And then fixation is really important. So once something is fixed in once an original work is fixed in a tangible medium of expression, it is subject to federal copyright protection. And that fixation element means anything from, pulling out your iPhone and filming something as kind of like a first draft sketch of what a scene is going to end up being in your motion picture, perhaps. It could be a voice memo on a phone. If you're working on a song and you come up with a nice melody and you record that, you've fixed it. It's fixed and someone else can come and listen to it. Or if you're writing out sheet music or you're writing out lyrics or a book, anything like that, once it's captured somewhere where other people can perceive it, those are the requirements. There were formalities required. You had to register, you had to have the copyright notice if it was published in order to have protection. That's under the old law. You don't have to worry about that stuff anymore. It can be helpful. There are benefits to using those kinds of formalities, but it's not required. So the only things that are required for a creative work to be subject to copyright protection is originality and fixation. Another important question to go over is why do we have copyright protection? Why do we want it? What are the benefits? How does it help me as a copyright owner? So there are these exclusive rights. We refer to it as like the bundle of sticks. The rights to reproduce, distribute, publicly perform, or display, depending on the type of work. Again, this goes back to, we have this big long list of different types of works that are covered by copyright law. But so if it's a song, you would be publicly performing that. If it's a piece of visual art, you would be publicly displaying it because you can't perform a piece of art and vice versa, right? So these are all of the exclusive rights that you have as the owner, as a copyright owner, and you can share those rights. You can, license on a temporary basis on specific terms. You can also assign them. So this is what you get. This is what you're after if you are. And we'll get into the work for hire agreements in a second, because I know that's why we're all here. So if you're wondering, do I want to have a work for hire agreement in place? Think about the kind of work and what you want to be able to do with it. If you want these rights, then a work for hire agreement is probably a good idea for you. Okay, so sorry, I'm realizing I had some highlighter on here, but it's not showing up. So the reason I keep coming back to this slide is because it was supposed to show we're moving on to the next section. So we're in the copyright ownership section now. So how do you come to be the owner? The basic rule is that the author of the work is the initial owner of the copyright. That's the default rule. There are other exceptions and other things, special ownership rules, but the default rule is if you have created something or if you've worked on something with someone else, you have an ownership interest in that copyright. So that's our baseline. Always remember that baseline when you're thinking about work for hire agreements, assignments, transfers, these kinds of things. But yes, there are special ownership rules for work for hire agreement, works made for hire under the work for hire doctrine. There are also special rules for joint works, compilations, and collective works. But we are here to talk about works made for hire. So so there's let me back up just a tad. So the Copyright Act of 1976 is what we're operating under now. And it went into effect in 1978. And so when you're looking at copyright issues, or if you're doing your own research online, a lot of times you'll see this distinction of, well, was it something before 1978 or after? So that's why. It's because there's a new law put in place. There was a copyright law previously that was, it's referred to as the 1909 Act. It was from 1909. So you can imagine the technology, the types of works that were being created changed quite a bit from 1909 to 1976. So they really felt like there was a need for some new legislation, and they pushed the 76 Act through. There have been a lot of amendments to certain areas of Copyright Act since then, but for the most part, we're still working with that 76 Act. With respect to work for hire, prior to 1978, when the 76 Act went into effect, there was a work for hire provision in there, but it wasn't exactly the same. And so I'm not going to get into this in too much detail, but just so you know, if you're thinking about works that were created prior to 78 and there's work for hire language involved, the analysis is going to be a little bit different. So just keep that in mind. And the 76 Act, so effective 78, created a pretty clear a standard for us that there are two ways for something to be considered a work made for hire: either created by an employee within the scope of their employment or created by an independent contractor. And I'm going to dive into this a little bit more. So this is the statutory section 17 USC 101. It's cast as an exception to that general rule that I mentioned earlier, that the person who created the work is the initial author and the initial owner. And again, the question is employee or independent contractor. If you fall into one of these categories, then it can be a work for hire. So works prepared by employees within the scope of their employment. The within the scope of their employment part is key. So because there have been cases where there's a question about whether someone was actually doing what they were supposed to be doing at work when they were creating something, or if they were not authorized, they were kind of doing their own thing, but maybe it was still in the same line of business as what their employer does. So there's a test for that. So we think about that. But I think that what most of you folks are probably going to be looking at is the independent contractor provision. And that looks at works that are specifically ordered or commissioned for use if there are two things: a written agreement in place between the hiring party and the creator, and the work has to fit into one of 9 categories. This is a chart, and again, I'm not going to go through this in great detail, but this shows kind of how to figure out that distinction between employee and independent contractor. It's a test that's used by the IRS for tax purposes, but it comes up in a lot of other areas of the law as well. And so I'm going to just move on from this, but know that if you guys get the deck later and you want to take a look at this, it can be a kind of a tricky analysis. There are a lot of cases about this, so this is definitely one area. If you think you're in the gray space, you would want to check with an attorney about it. So if I'm repeating a little bit, but I think it's important to drive home the point. So if you are an employee working within the scope of your employment on a creative work, the work is considered a work made for hire, and your employer is considered the original author. Full stop, unless there's an agreement to the contrary. So if there's an agreement that says, even though I'm your employee and I'm doing this within the scope of my employment, I still get to keep it and I still get to retain my authorship and ownership, then it's yours. But otherwise, the default rule for employees working within the scope of their employment is that it's a work made for hire, and their employer is considered the original author and original owner. It's the flip side for independent contractors. So for independent contractors, you have to have an agreement in place in order for it to be considered a work made for hire. If you don't have a written agreement, and you also have to fit into one of these 9 categories that we're going to get to next. But if you don't have that written agreement, it's not considered a work made for hire. The independent contractor owns the work. And so this is something that folks it's a little counterintuitive because you hear work for hire and you think, I hired someone to, record the guitar track on this song, or I hired a photographer or a videographer to work on this project for me. So I hired them, I should own it under work for hire, but that's not how it works. You actually have to have a written agreement that specifically says that it's subject to the work for hire doctrine under the Copyright Act. So, breaking down these requirements for an independent contractor. The first is that the work is specifically ordered or commissioned. So what does that mean? And this can get really interesting with folks who are collaborating, and you're wondering, maybe like, whose idea was this? Was somebody maybe working on something on their own already, and then another party came in and thought, oh, that's a cool project. Do you want to team up, or could I use that? Can I use some of that footage for my other project? And then they try to capture it through work for hire. That's not actually how it works. It's technically supposed to be only for situations where the motivating factor was the hiring party. So, I want someone to help me with a project that I'm working on, and I specifically say, hey, I'm going to hire you to produce this commercial for me, and you're going to hire you're going to film it and whatever they're doing, and I'm telling them what to do, and I'm paying them, and I'm giving some kind of guidance and exercising control, and it's ultimately they're the one creating it, but I'm the one that's telling them what to do. Then they are an independent contractor for me. We get that written agreement that says that they agree that it's a work for hire under the Copyright Act, and it fits into one of these 9 categories, and we're good. So, so these 9 categories can get a little bit tricky, and so I think a lot of you folks are going to be working under the motion picture audiovisual category, which is relatively straightforward. It gets a little complicated when we look at music and sound recordings. There's a little bit of tricky history here that I want to share with you guys. This was a little bit before my time, but in 1999, I believe, the Congress added to this list sound recordings. They recognized how the recording industry works, that record labels and artists were usually hiring, studio musicians and producers, and even the artists' agreement with the labels said that that their work was on a work for hire basis, and so it made sense to Congress to add sound recordings to this list. But there was some, as Congress tends to do, they kind of messed up. And it was supposed to be a technical amendment only. This was a substantive amendment. They ended up pulling it out in 2000, so a year later. That raises a lot of questions. Does that mean that we can still kind of use it? Because arguably there may be collective works. If we're having a bunch of folks that are working on a song together, can we still fit into one of these other categories? Or was that Congress saying specifically, no, work for hire does not apply to sound recordings? So what they did is they have this language that clarifies that the addition of sound recordings in 1999 and the deletion of sound recording in 2000, neither of those things we can't read anything into it. It doesn't mean anything. In most cases, when something like that happens, lawyers are allowed to look at that to help them interpret what Congress's intent was in interpreting a statute. Congress said, no, don't do that here. Ignore what we did, pretend it never happened. We're just gonna, shut that off to the side. And, you lawyers, you get to just look at these 9 categories and decide what you think it means without, you have to act like that never happened. So what folks have done, and this is, throughout the music industry, we just say, okay, it's either collective work or compilation. It fits into that box, and so far nobody has challenged it. But there's always this kind of question of whether or not it's gonna, rise to the level, get up to the Supreme Court or the Ninth Circuit. So it's something that we're always watching and we're always concerned about. We do have a workaround though. So we say that if when we have work for hire agreements, we usually say, we're working on this sound recording, we use my guitar player example, you contributed your guitar track to this piece of music. You agree that it's work for hire, subject to the work for hire doctrine, and that the record label is the original author and owner. You're giving up all of your ownership rights. And we add this backup assignment. So we say, if for some reason this is not considered to be a work made for hire under the Copyright Act, then we have this backup assignment where the guitar player hereby assigns to the record label all right, title, and interest into this piece of music, or the guitar player's contributions to that piece of music and the results and proceeds of their contributions. So that kind of is the catch-all. But I'm going to get into in a minute why we oftentimes will prefer, if you're the one that's commissioning the work, you would prefer for it to be a work for hire rather than an assignment. But by doing that, at least you make sure that the person who's asking, who's doing the hiring is in fact gonna own the work, even if there's some issue with the work for hire status of the work later on. So real quick, if there's no work for hire agreement in place, who owns it? So you have the original author, if it's just a single person. You also have joint ownership. And I'm going to get into that in a second. We also have collective works, compilations. So these are, if you have works that are, kind of separate different pieces, but they come together to make a different work, but they were created separately by different people with different intents. So think about like a compilation album, or a soundtrack would be a compilation album. These songs were created for different purposes, but then we bring them together for a separate compiled work. Derivative works are another kind of version of this, under this ownership umbrella. And derivative works are, they borrow from pretty strongly from an existing work. So much so that one of the exclusive rights that I mentioned earlier is the right to create a derivative work. So you have to get permission from someone to do that. So joint ownership, I bring up and want to get into this a little bit more specifically so you guys understand where joint ownership can come into play if you don't have work for hire agreements in place. A lot of times we're using work for hire agreements when you have, let's use a film example. So you have a production company and they have work for hire agreements with their director and their producer and their actors and their camera people and everybody that's contributing creative expression. If there are not those work for hire agreements in place, then arguably there's joint authorship and joint ownership among quite a few of those people, because anyone, the test for joint authorship is, anybody who is contributing to one single unified joint work. So, if you're filming a TV show or a motion picture, film project, all those folks are going towards that same goal of that one finished product. And as long as they're contributing substantial copyrightable expression, for the most part, with some caveats, that would be considered joint authorship. And so it's really important if you are a film, producer, or working for a production company. And then on the music side, if you are either the label or you're the artist and you're like an indie artist working with studio musicians and producers and engineers, bringing all those folks together, it makes sense for them to all be working on a work for hire basis. You're going to have special agreements and arrangements with different folks, but just think about the consequences of if you don't do that. If they're not working on a work for hire basis, then everybody is considered an equal author or owner without an agreement to the contrary. And that means that everybody has an equal share in those exclusive rights that I mentioned earlier. So there's some pretty big consequences there. You can always assign your rights and ask for an assignment, even if you don't have a work for hire agreement in place. But again, there's a different legal implication. Folks have different rights. So it's important to think about from that perspective of the folks who are asking for the work for hire agreements. And it's also important to understand as someone who is being asked to sign a work for hire agreement. So if you are the actor on that film project and the production company is asking you to sign a work for hire agreement, that's super standard, it's super normal, and you can understand why, because if they don't have you sign that, then you and everyone else could have a joint authorship claim, and it makes it really, really complicated. It's difficult for them to then go off and license and do things with that work if they have to clear it with everybody that's involved, or they have to worry about folks coming out of the woodwork to make copyright claims. So that's kind of why it works like this. So hopefully that gives you a little bit more context. So I've alluded to this earlier, but there are two big reasons why work for hire agreements and work for hire status is really important to folks that are controlling the work. So again, like in my example, the indie artist who's hiring all the musicians, or the production company who's hiring all of the talent and crew. Works made for hire are treated differently than other works under copyright law. So the one big thing is the duration. Normally, it's the life of the author plus 70 years. When we're dealing with work for hire works, it's either 95 years from publication or 120 years from creation, whichever is first. And when you're working on a project where there are tons of different contributors, it can be really tricky to figure out when the last contributor died plus 70 years. And it's very complicated to try to understand when all of those pieces come together. This way, if it's a work for hire, you know that everybody working on it has signed work for hire agreements. All you have to do is look at the date of the creation and the date of publication, count forward, and that's how you know when the copyright term expires. It's really important for folks who are exploiting their creative works, because a distributor or someone else who's going to potentially purchase or license those rights, they want to know. They need that certainty, and so this was put together this way to give them that certainty. Another huge one is the statutory termination right. So backing up a sec, unless it's a work for hire, so if it's an assignment to a third party, the original author and their heirs, only their heirs though, not other assignees, but the original author and their heirs have a right to terminate that assignment under the Copyright Act. This isn't always well advertised. A lot of folks don't know about this, but it's a really useful tool for folks who, and the purpose of it was, recognizing that a lot of artists might enter into agreements or sign away some rights to some really important works of art, or other creative works early on in their career, maybe, or it's the nature of this kind of business that things get exploited, and sometimes maybe you give something up that you wish you hadn't, and these kinds of creative works they're expressions of yourself and extensions of yourself, right? So this termination provision was really throwing a huge bone to artists and their families to say, hey, you get another bite at the apple. If you regret this assignment, you can go back, you can go get it back. So from the side of the record label production company folks, you don't want them to have that right, probably, because you want to know that you own it and nobody's going to come back. It's 35 to 40 years later after the assignment. You want to know that they're not going to come back and say, hey, actually, I want that back and I have the right to do that under the Copyright Act. If it's a work for hire, there's no statutory termination right, because the work is considered to be owned and authored by the hiring party from the inception. So this is a really big distinction. And for you folks who are thinking about whether you should sign a work for hire agreement, think about this, but also balance everything else. Know that work for hire agreements are very common in the industry. You have more leverage depending on the negotiating power of the parties and what your level of involvement is. But it's very standard for folks who are doing, I keep coming back to these examples, but like studio musicians, production crew, actors, all the big network shows, unless someone has a lot of sway, they're going to be signing work for hire agreements. It's going to be owned by the network or by the production company, and it makes sense for everybody to do it that way. So so those are two big things, big distinctions to note and to understand implications of the work for hire doctrine. So where does this come up? It's if you are hiring a team to work on a project, when do you have them sign this work for hire agreement if you want them to do it? There are a few different ways it can come up. Sometimes folks will have just a separate plain work for hire agreement. That works. If you are having them sign a lot of other contracts too, a lot of times people will just stick the work for hire language in those other agreements. So let's say you're doing a release, talent release for folks who are going to be appearing in your show. Maybe it's even extras, or just kind of a quick 1 or 2 pager saying, yes, you can use. You would probably have in there my name, my likeness, my face, my image, my voice, and any creative expression that I contribute is going to be covered by the work for hire doctrine under the Copyright Act. That's really common in releases, so you should expect to see that if you're being asked to sign a release, and if you're preparing releases, it's something you want to think about. It can be a nice kind of catch-all way to make sure that in case there's any little creative expression that someone performs when they're working on your project, especially if folks that are on camera, it's just covered and you don't have to go back later and say, oh, that person wasn't supposed to have any lines, but they did. And now I'm worried that we didn't get a work for hire agreement. You can just kind of, use it as a blanket thing and take care of that right off the bat. We also see kind of more involved work for hire provisions in producer director agreements for folks that are have a bigger role in a project. It can be kind of just as simple as what I've kind of verbally spit out earlier. Sometimes they're really long and they go through to just make it absolutely super duper clear that the production company owns the product or the record label or whoever is the hiring party. So those are, it's really common there. And then also a place that, and these are just a few examples, they come up all over the place, but another common one is if you are signing an agreement with, if you're a recording artist and you're performing and you're signing a contract with a venue, they might have something in there saying, we're going to record this. And if we do, it's, all of your creative expressions that we capture are work for hire. That's something you want to think about. Do you want them to have that? Because that means that they would be the original, considered the original owner of that work, that recording. So, stuff to think about. Those are just a few examples. They come up in a lot of different places as well, but those are kind of the few big ones that pop to mind. Other things to think about if you are looking at, preparing a work for hire agreement or looking at one is an indemnification provision. So you think about folks who are signing work for hire agreements, they are going to be contributing some creative work. And what happens if you get sued, you, the hiring party, get sued because a third party says that the person who you hired infringed on that third party's work. So let's say you hire a backup singer and that singer, kind of improvs some phrase of music, and then you release the song and you get a copyright infringement claim saying that particular phrase was infringing someone else's work. There are indemnification provisions in these agreements that cover that, so that it's saying, hey, you're going to promise me, you're working on my project, I'm hiring you to work on this, you're going to promise me that whatever you contribute is not going to infringe on the rights of third parties, and if it does, you're going to pay for it, or something like that. There are all different versions of this, but that's kind of the idea of indemnification. It covers the party that's doing the hiring in case of infringement claims and things like that, other types of damages. So those are pretty common in there. You want to think about that, especially if, depending on who you're working with and the nature of the work that they're providing to you. sometimes it's easier to control and have confidence that there's not going to be an issue like that that's going to come up. Sometimes it's really hard to predict. So think about covering your bases. And if on the flip side, if you're the one signing the agreement and there's a provision in there, you want to make sure that you're confident that what you're contributing is not going to be infringing other folks' stuff. And again, look at what the indemnification says, because it might not just be limited to other instances of copyright infringement. There are all kinds of things that can come up here, but you want to be aware of that and make sure you understand, what that's saying. It might also include grants of other rights. So if the overall main document that you're signing is a work for hire agreement, you can also throw in other things in there, like getting permission to use someone's name, face, likeness, things like that. And then it can be the flip side too, like I mentioned earlier. Sometimes maybe the main document is going to be a right of publicity license or something else, and in that there is embedded some work for hire language as well. So it can be really flexible depending on the kind of documents that you want to put together and how you want to be setting up your deal with someone. Think about other conditions as well. That yes, this is a work for hire. I'm agreeing to that this work is a work for hire on behalf of you, but there are these conditions. And if you, I'm doing this based on your representation that X, Y, and Z. And if X, Y, and Z turn out not to be true, I'm rescinding this agreement. So think about that. And again, these contracts and agreements are important because for independent contractors, the work can only be subject to the work for hire doctrine if there's a writing, right? As we talked about earlier. So if you don't have a signed writing, even if everyone agrees, it's not going to be considered a work for hire agreement or a work for hire work. And the last thing there is that backup assignment, which I mentioned earlier. So I have a couple kind of common questions here. So who can be a work for hire owner? We kind of touched on this, but it can be anyone. It can be an individual, it can be a company. It's the hiring party. It's the person who says, hey, I want you to do this thing for me, and here's what I want you to do, and I'm going to pay you for it. So it can be in different contexts, based on the industry and based on the situation. Again, it could be a producer that's hiring the studio musicians on a work for hire basis. And then maybe the artist hires the producer on a work for hire basis. So you can it kind of stacks up in some situations as well. But it's really anyone who's doing the hiring. When do you need it? And maybe the way I worded this question isn't super clear, but there's a timing element. So generally you want to get this done before the work begins. If you don't do that, you can do it after, but there's this rule and it's really hard to prove. So it's kind of a squishy rule, but the idea is that if you sign the agreement after the work has already been performed, it satisfies this signed writing requirement if there was already some kind of verbal agreement in place or some, shared understanding between the parties that it was going to be a work for hire and we just hadn't done the paperwork yet. So this can get a little tricky. There can be a lot of he said, she said, and that's why it's better to just get it done beforehand, make everything, all the expectations and everything really clear. And, this question comes up a lot, and, when should or shouldn't I sign a work for hire agreement? It's, I can't say for sure, it depends on you and what you're working on and your relationship with the parties and what the long-term expectations are. Certainly if it's a one-off thing, or if it's something where it's worth it to you. And I think, creative folks face this issue a lot. Do you want the opportunity, or do you want to, own, they say like owning 100% of nothing means that you own nothing, right? So if the opportunity to work on a project means you have to sign a work for hire agreement, a lot of times that's worth it. And I don't want to make it sound like, you're signing your life away and you shouldn't do this. At the same time, I don't want it to sound like you should always sign work for hire agreements when you're asked, because it really just depends on the situation and your connection to the work and kind of the nature of the deal. Another question that we get a lot is whether the work for hire doctrine applies internationally. So There are other countries that have work for hire doctrines. They're similar. Some of them are a little bit different. There's no kind of uniform law. So that's something to think about. If you're doing projects in other countries, you probably want to check with, the laws of that place and kind of understand how it works, so that you again, just have all the expectations and everything's clear going into it. So I am almost out of time and I want to leave time for questions, but there's just one more thing that I want to touch on very briefly, because this is also super important for you guys to know. And this is about, it feels a little off topic, but it's not, I promise. This is about an income tax exclusion that a lot of you could probably be claiming. Hopefully you are claiming it. It's 235 7.3. Make sure your CPAs know about this if they don't. Anyone who's deriving income, it's called the royalty provision, but it's royalty income or other income that's derived from patents, copyrights relevant to you, and trade secrets. With some caveats, any of that revenue is excluded from gross income in the state of Hawaii. This is just your state taxes. This is not, federal taxes with the IRS. But the key here with respect to work for hire is that in 2000 or 2001, there was a bill that my boss, actually, Bill Meyer, worked on getting passed to amend this provision to add this language that's underlined here about the work for hire doctrine. So this said that even if you sign a work for hire agreement, so you don't actually own the work, you are not considered the original author of the work because it's a work for hire, you can still claim this income tax exclusion on any income that is derived from exploitation of that work. So this is, I know it's confusing and complicated because it's a tax thing. It took me, several tries to kind of wrap my head around it. But this is really big and it can be really, really helpful for you folks. Taxes are a huge pain. And so I want to make sure that everybody understands this, and I'm happy to answer any questions about this or anything else, but it's, I'm not going to go through all of the statutory language because it can get a little dense, but just know that if this is something that you think might apply to you, talk about it with your CPA or reach out to an entertainment and IP lawyer in the state. We can kind of point you in the right direction, but generally be aware of this and know that it could apply even to income that's derived from work for hire projects. All right, so that's awesome. What I got.
Thank you so much, Julia. Much appreciated. So if you can exit the slide presentation, that would be awesome. So I know that someone has asked a bunch of questions, but before we start that element of that component of the webinar, I just wanted to re-anchor the viewers that this is about work for hire agreements, and specifically for the audiovisual and music creative entrepreneurs. So if you've asked questions, make sure that the context you're putting them in are around this subject, because I'm seeing a bunch of questions come up that do not necessarily fall under that. And please ask your questions now, and Julia and I will do a couple of role plays, because obviously one of the biggest things with work for hire agreements is that if I'm talent and someone with money wants a service being provided by me, they would give me a work for hire agreement, and I would get a certain amount of money initially for providing that service and that work. And depending on my experience, depending on my background, depending on how badly they want me, I may be able to negotiate things like residuals or things like that involved. But typically, for, I would say, up and coming creative entrepreneurs, that would not be something that they would be able to go after. So given that, what is the biggest mistake that you see as an attorney that creative entrepreneurs make when potentially entering to work for hire agreements?
That's a good question. I think one mistake is not entering into them. Perfect. I think people get scared, and I get it, because you want to hold on to your rights, right? And you work really hard on something, and but But yeah, I think that it's just it's a constant balance of what makes sense and what the opportunity is, and is it really worth it to give something up. And if you're doing this every day and you're constantly working on projects, then there's going to be something else that's really cool that you get to work on. And of course, it's such a personal, it's a personal decision and a business decision. So it's really not for me to go and tell someone like sign the agreement. It's my job is to just make sure that everybody understands. But I see this where someone will say, you know what, it's not worth it. I don't want it to be a work for hire, and they walk away from it. And I get kind of sad because I feel like they miss a really cool opportunity. Yeah.
Yeah, I agree with you. I think, as a producer and as an executive, oftentimes what I found is people hold on to their initial ideas so tightly, and they let opportunities go by without realizing that this could be one of many opportunities that this work for hire agreement could provide you, right? Put you on the map and bring you some money and so on and so forth. So from the perspective of the individual who's doing the hiring, right? What are things that you should consider to make sure that you're hiring the right person for the job? What are things that you as an attorney for producer or a company that's looking to hire someone to write some music for them should consider when hiring someone to do this kind of work?
Yeah, so I don't know that these are necessarily legal considerations, but yeah, but just looking at, it's all, again, it's like all the creative fit, I think is huge. But also, yeah, think about from a business perspective and kind of long-term, what are your goals with this project? Especially on the music side, does this person have a publishing company or a record label that I'm going to have to work with? They might have, other agreements that are going to totally maybe not mess with, but affect the way that our relationship is going to be able to go. So you have to, think about all of those things too. I think, ideally, even if they have other existing agreements with other folks, the purpose of those agreements is still to get in the same direction, which is creating more and doing more cool stuff, but it doesn't always work out that way. So I think that's a big thing to always think about, and make sure that you are not interfering with those contracts, because that could be a business tort liability thing. You just want to be aware of kind of, what the whole situation is. And again, that, that creative fit piece, I think is obviously really important, and going with your gut on those kinds of things, having a good sense of what someone is going to provide and how into the project they are, all of those things obviously matter a lot too. But yeah, I think from a kind of business side, you don't want to get stuck working with someone that it's going to drag down the project.
Yeah, no, I agree. I think that, and I love what you said, because so much of it from the hiring perspective is also, how busy is this person? How many other projects do they have going on, right? What are these people like to work with? Should I be checking references or find out from other people what they were like? Do they deliver on time? Do they not? And to your point, do they have deals that could preclude my deal, right? Yeah. So much of that also needs to happen, and it comes with, being able to have these conversations and also being able to be transparent and authentic about how busy I am. Can I make the deadline? Can they make the deadline? Right. So making sure that it goes beyond just the idea or the needs, but also where does this project fit in the life of the creative entrepreneur? And what is their reputation of being able to deliver and this kind of things, right?
Absolutely.
Perfect. Great. So I'm going to go into some of these questions, and I'm going to ask them as they wrote them. And I'm going to look to make sure that we put the work for hire lens through it. So bear with me. So thank you for all the information. This is very important for creatives in Hawaii. What about creative works that may include cultural practices and protocols? If possible, could you speak about or add any information regarding working with Hawaiian elders and how I would make sure both Indigenous and Western values are considered? I want to be Pono in my approach. Any suggestions or areas where I may find more information would be appreciated.
Yeah, that's a great question. I think that's something that we see, that's an issue that we see a lot. And, doing work here in Hawaii, there are so many cool stories that, want to be told, that involve local culture. And I think that there can definitely, we see a tension, between copyright law and just general, like Western Americanized business practices. And so you do have to strike that balance. And I think folks who are really successful here, especially the folks who are working in that space, are able to kind of, I don't want to say, but it's not that they're two completely competing things, but it's something that you do have to be able to navigate. I think communication is really important. We work with a lot of folks where, we maybe are representing the filmmaker and drafting those agreements, but we try to bring everyone into the conversation. And so we'll have clients that ask us to help explain something to someone that they want to work with so that they understand why, they're not just shoving some paperwork in their face, but it's like, okay, here's why we have to do this. And we can soften it up as much as possible. We don't use as aggressive language, or, we take those things into consideration, and it can go a long way in just making folks feel comfortable. But you also have to think about, if you have a film project and you want to get big time distribution, they're going to want to know, do you have all the rights? And it's something that's really difficult with music as well. There have been a lot of potential opportunities, but the publishing is so hard to figure out because there are so many songs that nobody really knows who wrote it or who owns it. They've been, passed down. The tradition of gifting mele to people is beautiful, and I love that, but it's a nightmare on the clearance side because it's like, oh, I don't know, my tutu said that so and it's like, oh my gosh, okay, how do we do this? Because you want to make it work, but it's just complicated. There's also some other legal tools that we can use that, depending on how much risk someone is willing to take on. I kind of mentioned earlier indemnifications, and so maybe someone says, to going back to the distribution example, let's say, you're working on a show and there's a bunch of artwork that you can't clear. You're working with local or, cultural folks who they're not giving you the information or whatever the issue is, and you don't want to go there with them. And so you as the filmmaker can just say, okay, I'm going to step up and just say, if anything happens, I'll take the hit. So that's another way to do it too. So it can be really difficult, but it's also, it makes the work so much more rewarding. And that's why a lot of people, run into barriers and can't make those kinds of projects happen. So if you just kind of push through and have a good team to work with, and communicating is super key.
Okay, so I'm going to ask some of the other questions that have been asked, even though they clearly do not fall under the concept of work for hire agreement. Feel free to say, that's not my expertise, or it's not something that I can speak to.
Okay, let's go.
They're all from the same person too. So, and I know that they're working on a project that involves elders. And what they're really looking to do is make sure they're protecting everyone in this process, because they're really committed to honoring elders and the traditions and so on and so forth. So, all right, so the next question is, what about videos to make and put on YouTube or TikTok? Is there any protection a person can use for that? My assumption there is that if you copyright the material, it's yours to own and distribute.
Yeah, so you're talking about protecting the person who's making the video, not the person who's in the video, I'm assuming. Yeah. So, I guess it's like, protecting it from what? So if you again, if it's fixed, so an intangible medium of expression, and it's this creative work, it's subject to federal copyright protection, but there are things that that only gets you so far. If you want stronger protection, you can register the work, and if someone who is in the video you didn't get a clearance from, they could come back and say, it could be anything from, a copyright claim. It could be breach of contract. Maybe if they say that you guys, you said you weren't going to put that video online and then you did, that could arguably be a breach of contract claim. There could be a right of publicity issue if they didn't give you permission to, have them appear and have their voice. So there's that issue. But in terms of if you're trying to do something else with that and show someone else who's interested in licensing that piece of work from you, have a copyright registration, say that, you're going to represent a warrant that piece of work is protected and that it's not going to infringe any other rights. And then you're the one that's going to have to take the hit if it does.
Got it. Perfect. Thank you so much. I'm going to ask this last question before we wrap. So, so again, the same writer producer is asking this question, which is, when one of the things that they're committed to doing to bring authenticity to the project is to be able to collaborate with elders in the Native Hawaiian community to ensure that the material, the written material, reflects these sensibilities, this authenticity, and this truth. So the question speaks to, and they use the word collaboration. So in workshopping these ideas or having meetings of these ideas and discussing these ideas before committing anything to paper or hiring anyone to do so, what sort of agreements should this producer enter with the people that they are working with to ideate this? Should it be a collaboration agreement? Should it be a work for hire agreement? What would bring the most protection to the person who's looking to produce and will eventually use their own resources to finance and produce this?
Yeah, that's a great question. So I would say, based on what you're saying, I mean, I don't have all the facts, so
Totally
don't quote me on this, but it sounds like maybe a collaboration agreement that has some work for hire language in it. So, work for hire might be too limited for this situation because you're in the early stages. So setting those expectations of, here's what we're doing at this early stage, and then here's what it's going to look like later on. And that later on part might be where the work for hire stuff becomes relevant. But yeah, it is, and it's tricky because you want to have everything documented, and a lot of folks do understand and appreciate that when you're saying, hey, I'm not trying to over lawyer this thing. I just want to make sure that we're all going to spend a bunch of time and effort on this. Let's get some stuff in writing so that all of our expectations are clear. And if you approach it that way, rather than just, I'm a filmmaker, I saw this panel and she said to have you sign an agreement, I think it can be a lot more palatable. And you probably want to be having those discussions with someone anyway, if you're going to be working with them. So getting that stuff down, even if it's just some emails back and forth, so that you have it to look back to and reference and say, okay, you said you were going to do this, and I said this was going to happen, and so-and-so wasn't going to take any money, or whatever it is, then and everyone's on the same page. So I don't know if that really answers.
No, it did. Because I think one of the beauties about this is also to remember that a lot of these agreements can also be opened up and renegotiated if everyone's working in good faith and in a collaborative fashion. Because I think a lot of, especially emerging or nascent creative entrepreneurs, are terrified to go into these types of agreements, thinking that they can't be changed, or that one. But if changes, projects are these living things, and things shift and change, availabilities change. So a lot of this stuff can be renegotiated and opened up again based on the needs of the individuals. So perfect.
Yeah, that's totally right.
This is all the time we have today. I just want to say thank you so much, Julia, for working with us and providing us this incredibly informative presentation and conversation. Julia did touch on trademark and copyright law, which were 2 webinars, which we did at the beginning of June with Martin Shaw. So if you're interested in doing more of a deep dive in those 2 subjects, please go to our Facebook page. Our Video On Demand library contains those videos. This is the last program I'll be producing on behalf of Creative Lab Hawaii and the State of Hawaii DBET Creative Industries Division. It's been a privilege to work with the team at Creative Industries, which includes Georgia, Tracy, David, Naomi, and David Nada, who's now retired, our partners in the state and the entertainment industry, and the thousands of you who participated in our programs. On behalf of the State of Hawaii DBET Creative Industries Division, mahalo and have a great day. Take care.
Thank you, Michael.
Bye.